The following information and opinions expressed on the Sweet Divorce podcast do not constitute, nor are intended to be taken as legal advice. All content is generalized and for informational purposes only. Please contact our legal team or your own attorney for advice specific to your particular case. Thank you.
We'll help pick up the pieces one by one. Information straight from the source. It's Sweet Divorce.
Hello and welcome to today's podcast of Sweet Divorce. I'm Rosario Burgos Santoyo, a founding partner of Burgos Santoyo Smith.
And I'm Gretel Smith, also a founding partner of Burgos Santoyo Smith.
Today we have two lovely guests that are hopefully going to be regulars, our latest additions, Krista Jones-May and Dina Miners, who are with us from Illinois.
Hi, everybody.
Hi.
And welcome. Yay.
Yes, welcome to the firm. We're so happy to have you. So tell us a little bit about what we're going to be discussing today.
So what we're going to be talking about today is mediation and how it works specifically in Illinois. Mediation tends to be involved when it's a case with children. So whether it's a modification, a new case, unless there's a full agreement from the start, mediation is going to be in play in any case when there's children involved.
Can you tell us a little bit more about the mediation process in Illinois?
Sure. So the mediation process in Illinois, like Dina was saying, most people are going to be required to go to mediation when they have a case involving children. The mediation process allows you to sit down with your opposing party and also sit down with a third neutral party mediator who's going to help facilitate the conversation between you and your opposing party. So you guys can work together to find a compromise of sorts to see if you guys can both work together to get to a position where you're both comfortable making the decision as to what is going to happen with your children. So it's really the first step before you can even start talking to a judge and have a judge make the final ruling as to what will happen with your children.
So generally, what's the experience of the third party neutral, of the mediator?
So typically they are either an active family law attorney or a retired judge. But the important thing is to remember they're not acting as an attorney or a judge. They're not there to tell you what to do. They're not there to tell you how the judge would rule. They're really there to help guide a conversation between two people who might not be happy to communicate at any given time.
I have a question. In the mediations in Illinois that you guys do, are they recommending mediations, or is it there for you to help reach that compromise? In California, for example, we have reports for our mediations and they're recommending often. So are you guys doing recommending mediations, or are they just, we're meeting with the parties to come to an agreement?
So mediation in Illinois is required for all cases that have children involved. When you do go through the mediation process, the mediator does furnish a report of the mediation to the court, but it does not tell the details of what any agreement was. It just says whether the parties attended and whether they came to either a full or partial agreement on the decision-making responsibilities and on the parenting time.
Because mediation, of course, is not binding if there's an agreement reached until it's actually put into an order and the judge signs off. Either party can change their mind, seek clarification, additions. A lot of times they start off with a temporary agreement and then that can build later into a full agreement. So it's important for people to remember that just because you agree doesn't mean you can't talk it over with your attorney afterward, because I know that's important to a lot of people.
So it's non-binding. That's a good point also. And the expectation too, just because you reached an agreement in mediation, I like the idea of sort of having a test drive and seeing if it actually is able to, put the logistics in place. So that's great.
Yeah.
Do you have anything you recommend in preparation for mediation?
First, talk to your attorney so you know what your rights are. I think a lot of people go into mediation not realizing, what maybe a standard schedule would be, what they might want to see out of mediation. So it's important to talk, about what your rights are going into it, what maybe some outcomes you might be looking at, so that you can go in to properly negotiate. Because if you don't know your bottom line, you might agree to something that as soon as you leave, you regret, or you might not be able to propose an alternative schedule because you haven't thought it through. So because mediation is so much about compromise and having a guaranteed result, it's good to go in knowing what you're looking for and what your bottom line is.
But in addition to that, it's also important that you understand why you want a specific schedule. So if you're going to come in and say, listen, I would like to have this set schedule, I always tell my clients, you got to take it seriously, but you also have to make it make sense for you. When you are going into mediation, you can't, or maybe you shouldn't necessarily ask for Tuesday nights if you know you work overnight and you can't get the children where they need to go, either on Tuesday nights or Wednesday morning going for school purposes. So also in preparation, you have to think about your life, your children's lives, how those schedules tend to fluctuate. Maybe it makes more sense for you guys to do a schedule where you can pick up and drop off from the school directly, or maybe the work schedules just don't work that way and one parent is always home at 3 o'clock for the children to get home from school. So it may make sense to do a 4 or 6 p.m. exchange time. So there's a lot of understanding your rights that needs to go into preparation for mediation, but you also have to apply those things to your real life, because I think sometimes people miss that piece when they're like, it's 50-50 or bust for me. Okay, what does 50-50 look like though in your lives? Can we exercise it that way? And what makes sense for the children, because ultimately that's the standard here, is we have to produce an agreement if you come to the full agreement in mediation, or produce something to the court that we say, this is in the children's best interest in this case specifically.
That's a good point. Sometimes people get so hung up on the percentages that they don't really think of the actual schedule, which is the point of going to mediation, knowing what time the pickup is, what time the drop off is, where the child will actually physically be, as opposed to just coming in and saying, I want 50-50 or I want, 30-70. That's a good point.
I think it's also important in mediation to remember, obviously you need to keep an open mind, but if you're going to say no, because you have every right to say no, you need to say no, but offer something in the alternative, because if it's not a back and forth, then there's not going to be any progress. So just like with a, settlement proposal or something like that, you have every right to say no, but be willing to throw out an alternative to kind of bridge the gap.
Do you find times when you're doing mediations where it's just not something where mediation might not be appropriate in the case?
Yes. And I think, if you're so far apart that it's not meaningful, then even though you might not be able to agree on everything, then it's about the small things. So maybe you can just agree on exchange times, or maybe you can just agree on who's going to be the healthcare providers or holidays. Any agreement reached in mediation is one less thing you have to litigate and something you have a say in. So maybe it's not a case where you're going to get to the big decisions, but even if you can chip away at the smaller things, that can be a level of success.
And in specific counties and from certain judges, if you are in a position where there are some underlying sensitive case issues, like maybe domestic violence is involved in the case, sometimes the judges will allow a bypass of the mediation, because we don't want those two people in the same physical space for either safety reasons or just because we know that there's not going to be any meaningful progress that can be made there.
So what do you consider a successful mediation?
I think a successful mediation is going to be any time when you guys, the litigants, can keep control over what is going to happen. For me specifically, I don't love being told what to do. And I suspect that there are a lot of parents out there who also take that position. They don't want to be told what they can and cannot do with their child. Mediation is your last stop before you can get into the position where you start losing that element of control. It's really your last option to say, yes, I'm willing to do that, or no, I'm not, before the judge comes in who, quite frankly, doesn't know your kids as well as you know them. And they're just kind of looking at your case in a more clinical view. So I think it's your last stop to be able to say, this is what I think is best for my children, and this is what I would like to do or am willing to do, even if it's not my perfect scenario.
Have you had any mediations where they started out well and then just completely devolved into insanity, so to speak?
Well, and I think the thing is, there's a reason most people are going to court because they can't reach an agreement, right? So I think we all try to start off on the right foot and we want to have meaningful discussions, and then emotions get involved. And that's when things, tend to spiral out of control. But that's when you can take a break, right? That's when you can say, you know what, we've talked a lot. We want to sleep on it, think about it. Mediation doesn't have to be sit down once and that's your only chance, right? It can be multiple sessions. It can be, I just need to think it over, talk to my family, and that's okay too. I think sometimes we feel the pressure of it has to be done, has to be done, has to be done, that you might enter into something or be unwilling to consider something that if you just get a little breath, get a little time, that you can come back to the table and actually, have a meaningful conversation about it.
That's a good, so in Illinois, then, when you guys are ordered to, when you're doing the mediations, your parties can come back, the litigants can come back multiple times with the same mediator?
Yes. So
That's an excellent
typically
idea.
most people, generally, the statute requires that the parties would attend 4 hours of mediation. Some people do choose to do more because mediation is working for them. So after you complete your 4 hours, if that is really working for you and you guys just need more time, oftentimes that can be scheduled individually between the parties and the mediator. But typically everybody tries to reach that 4 hour threshold. If things break down completely before then they can terminate the mediation. But most of the time the judge is wanting the parties to go through at least the 4 hours of mediation to say that they've given it the best try that they can do.
How much information is the mediator provided prior to meeting with him or her? Do you give the whole background of the case? Is this something that they review the file prior to sitting down with both parties? Or is this a surprise just on that day, focusing only on what each person is saying that they would like for the child?
So typically in mediation, and it varies a little bit county by county and what the mediator seeks out beforehand, but mediators are always provided, obviously, the party's name, where the parties live, the children involved, their ages, kind of where they reside, whether it's both, whether it's primarily with one. That way, the mediator has a little bit of information, but typically they don't have the pleadings because we do want them to act as a neutral third party, right? They're there for the conversation. You don't want to give them so much information that suddenly they have opinions and are interjecting themselves more as an attorney or judge than rather as a mediator. So while they have typical information, they'll usually at the beginning of mediation speak to both parties individually to get an idea of where they're starting from, what they would like to see, so that they can have a basis for the conversation, but not so much the pleading side of things, because again, they're not there to act as a judge.
They remain neutral, like you mentioned.
The hope is that they remain neutral.
Do you find that parties who seem so reluctant to agree to something because they know that it's coming from the other side are more receptive to the same suggestion coming from a third party neutral?
Yes.
Yes.
And
definitely.
I think sometimes you just need to hear it, right? You need to hear it from someone else, because with litigation, you are on opposing sides of a battlefield, right? And the new mediator gets to come in, try to wave the white flag, try to give them a say, because as we know from theory and practice, you get in front of a judge, you have usually one day to explain an entire person's life, why they're a good parent, and then the judge has to flip a coin, because one parent is going to bring in all the witnesses they know are going to say nice things about them. The other parent is going to bring in all the witnesses that are going to say nice things about them. And the judge has to decide in one day what they think is right. And what the judge thinks is right might not make sense for the children. It might not make sense for that particular family. But the judge only has the ability to hear so much information before deciding. At least with mediation, you know your life, you know your schedule, you know your kids, so you will have more knowledge going into it to know what's going to make sense for your family.
any final words?
Mediation is a wonderful thing. Ultimately, if it's up to the judge, it's in the judge's hand, and you hope they make the right decision, and the judge is going to try to make the right decision. But in the end, that is a stranger. In mediation, you have the ability to figure out what's best for your family, to come to a compromise, and to really have a say in the end result. It can be a very meaningful practice. It can be a very helpful practice, but go in prepared. If you don't go in knowing what makes sense for you, you're not going to get a good outcome. So be open to listening, and hopefully it ends in the beginning of building a bridge with someone you might not have a relationship with, but that is the other parent in your child's life.
Thank you so much for joining us today.
In the silence of the night, echoes of a fading fight. Two hearts once intertwined, now severed.